Hey folks, Eric is the whatever guy because it really is whatever for me. And do you folks want to know about the Alabama medical cannabis cartel opposing these depositions by these commissioners? You guys stick around, man, and we'll talk about that. As you guys know, man, my name's Eric. I'm the whatever guy, and I usually shoot videos a couple days a week, basically keeping you guys updated in the world Delta 8, Delta 9, Delta 10, hemp, cannabis, what's going on around. And having said that, man, sitting here bullshitting around on early Friday morning, getting ready to start the weekend. And as you guys know, got a lot of work going on for myself as far as the work that I do for Boro Hemp, and then obviously on the weekends I'm trying to get a location up over at Highway 29 in Cantonment, Florida. So my plan is to run over there sometime today or tomorrow, later this afternoon, and to get some video up and get the cameras going. And we've got the inside painted, and so we've got a toilet I've got to fix and get it ready to go. So the bathroom's ready to go. So we're moving forward with that. And hopefully sometime next week or the week after we'll be opening that location. But talking about this Alabama medical cannabis cartel thing that's going on, and let me just say this too. I didn't shoot a video. There's a lot of news coming out. It seems like when there are dry spots in the news, like there's no news, and then like when there's news, there's just a lot of news. And like there was news yesterday. This article actually came out yesterday, but yesterday was my birthday, man, and I just didn't feel like shooting a video, and so I just hung out. I still worked, on the computer and stuff, but I wasn't doing anything outgoing as far as anything else went. So that's why we went no video yesterday. But moving forward, talking about this article over here at Alabama Reporter. As you guys know, Josh Moon wrote this article. We've talked about Josh Moon before. Josh Moon tends to write with the people that are kind of paying him or the people that are pushing information his way. And so I understand that Josh Moon is somewhat of a hack, but in this article here, he's kind of pointing out a lot of just basically reporting on the news. And so I like that about his articles. Sometimes his articles do point out just news without too much of an opinion. But we're going to go ahead and take a look at this over here, and we're going to find out why the Alabama medical cannabis cartel does not want the applicants to be able to deposition these guys. It says AMCC files appeal and wants appeals court to block depositions. It says the AMCC really doesn't want its commissioners to have to answer questions under oath. You can't argue that because because if that happens, like my understanding is that like they want to depose six commissioners. I believe one of those is John McMillan. So it's 5 commissioners and John McMillan. It boils down to the Judge Anderson allowed 7 hours of deposition apiece. That's 42 hours worth of depositions. They want to know why they violated the Alabama Open Meetings Act. They want to find out why they voted for these companies the way they did. They want to find out why some of these companies were given workarounds. So we're going to hopefully find all that out. But in the meanwhile, the Alabama Medical Cannabis Cartel has basically appealed this to a higher court. Now, let me just say this. Usually appeals, when they go to higher courts, are not on judgments. They're more or less on rules and statements and stuff like that. This is an actual appeal of the judge's order. So I'm not sure how that's going to play out in the appeals court, but we're going to check it out and see what happens. So let's check out and see what this article says. It says the Alabama Medical Cannabis Commission officially filed an appeal on Wednesday with the Alabama Court of Civil Appeals, asking the court to overturn an order issued by a Montgomery County Circuit Court judge that allowed several plaintiff companies to depose AMCC commissioners and obtain numerous documents. The appeal by the AMCC claims that Judge James Anderson erred in issuing the order because the plaintiffs had not yet exhausted all administrative remedies and because it offered insufficient evidence that violations of the Alabama Open Meetings Act occurred. The trial court exceeded its discretion by issuing the discovery order because the challengers have not satisfied the prerequisites for obtaining discovery on either Alabama Administrative Procedures Act or the Alabama Open Meetings Act claims. The petition for writ of mandamus states. Anderson issued the order in early January after the AMCC awarded medical cannabis licenses for a 3rd time. It was also the 3rd time that the court had stopped the issuing of these licenses after determining that the AMCC had, in various ways, failed to follow state laws and other requirements during the process. The AMCC publicly acknowledged that its scoring process, the primary target of the first round of lawsuits by plaintiffs' companies, was flawed, and it voluntarily rescinded the awarded licenses after the filing of the lawsuits. After the 2nd round of licenses were awarded and more lawsuits were filed or ongoing ones amended, the two sides entered into mediation, mostly centered around the AMCC's lack of compliance with the Open Meetings Act and its failure to follow the Alabama Administrative Procedures Act, which governs all state bodies. Coming out of mediation, the AMCC once again essentially acknowledged mistakes and agreed to make certain changes. It also agreed to again restart the licensing process. Following the 3rd attempt, which occurred in December, More lawsuits were filed and amended, taking issue with the AMCC's continued lack of transparency, particularly in relation to AOMA requirements and a scoring process that allowed a minority of commissioners to essentially deny a company a license, seemingly in violation of the AAPA. The plaintiff companies asked the court to again issue a temporary restraining order that would prevent the licenses from being issued and to allow discovery, including depositions, to help answer questions about the AMCC's troubled licensing process. In its appeal, the AMCC claims that Anderson should have denied the request because the plaintiffs, as part of the administrative procedures governing the AMCC, have an option to appeal the decision of the AMCC and could be granted a hearing. But in his order, Anderson addresses that issue by noting that the appeals process would essentially be useless since the AMCC would have already issued its limited number of licenses. In fact, Anderson granted the AMCC additional time to consider issuing its own stay of issuing licensing process until already filed appeals from the several companies could be heard and dealt with. The AMCC at its December 28th meeting passed a motion declining to issue a stay and stated it would move forward with issuing licenses. So they had an opportunity to stop these licenses a third time. I'm assuming because of all the stuff that's going on that they decided that they were going to go ahead and just try to push through. And so now we're in this position where the AMCC is going to appeal the judge's order that they allow deposition. They're appealing it to a higher court. In addition, Anderson held hearings on these matters during which the parties presented evidence and argued their cases before him. After that hearing, Anderson determined that the allegations had been proper conduct, specifically related to violations of the AOMA and the AAPA, were enough to warrant moving forward with discovery. Appeals courts typically stick to matters of procedure and don't often intervene in matters related to a judge's opinion. That's my understanding also. During a status hearing last week, Anderson told parties involved that it was his opinion that limited discovery would assist the court in making rulings on various matters as the case progresses. The AMCC, however, argues that in its appeal that allowing the depositions of the commissioners would be akin to harassment. As it stands, nearly 3 years after the law allowing medical cannabis was passed, the AMCC has still not been able to issue a single cannabis license. Guys, like I said, I'm not sure that we're ever going to see an end to this. Like if they really wanted to get this over with, they would just go ahead and allow these depositions and go ahead and get these questions and all these answers and stuff out in the open. But it appears that we're not going to be able to do that. It appears that now we're basically in a standoff. I'm not sure exactly when we're going to hear this appeal. This appeal up at the higher court. And we may be put off indefinitely for all I know. And like I said before, as we move forward into this legislature, we've talked to some representatives already that have basically stated that they are more inclined to kill SB 46 rather than trying to fix it in the legislature because they've already got a whole bunch of other stuff to deal with the gambling and the prisons and the school choice and everything else they got going on. They don't feel like they've got enough time to deal with this right here. They would rather just punt this down the road and wait for federal legalization. All right, folks, whatever got signing off, and I will talk to you guys later, man. Love it. See ya.